Hello, everybody. Welcome to the Mixer. My name is Alex Rose, and I am your faithful host for the evening. I am with Seattle's Office of Film and Music, and our mission is to support and equitably grow the creative economy here in Seattle with a focus on strengthening film, music, and nightlife and special events sectors. I myself, and I believe many of you are tuning in here on Indigenous land, the traditional territories of the Coast Salish people, and just want to continue to remember that. Here, I just want to take a minute to thank our partners, Washington Filmworks and WhipSmart. You'll be hearing more from them in a second. And give you a sense of what we're going to get into today. So first we'll talk about Washington Filmwork and WhipSmart's statewide social safety net survey and what they found. We'll get into the distinctions between independent contractors and employees. I know there are so many questions about the differences between the two, the benefits, the drawbacks, and then we'll get into just a general Q&A. Why don't we move to our speaker introductions? We've got some really knowledgeable folks who can't wait to share their expertise with you this evening. And so I would love to turn it over first to Jared. Go ahead and introduce yourself and tell us what your connection to this topic is. And if you have any connections with creative industries, let us know that as well.
Thanks, Alex. Hi, I'm Jared. I'm one of the presenters on independent contractors today. I'm a labor and employment attorney with Foster Garvey, a firm based here in Seattle. And I do employment and labor, labor being union work for mostly on the side of employers and I've been doing that for about 10 years now. My connection to the arts, and I think the reason I got connected here is I'm currently serve as a member of the board of trustees for the Seattle Children's Theater, and I'm a past board member for Shunpike. So I've tried to, in my non-paid work, trying to branch out from kind of the boring legal stuff and find a way to interact with a different kind of industry and a different group and arts groups, and really find a way to apply my skills there too, and in an area that I'm interested in as a consumer of art. So thanks for having me.
Thanks, Jared. Ben, you want to go next?
Hi, everybody. I'm Ben Byers. I'm an attorney at Core Cronin. We do litigation, and a fair amount of that, especially these days, is involved with employment. Got invited to this group through the Washington Lawyers for the Arts. I worked some with them in law school, and then know several people who are with the organization now. One of the things that I've been doing a fair amount during the pandemic is advising a sports management company that works with Olympic athletes and is starting to produce a lot of content, particularly online shows, working with websites like SwimSwam to do videos, workout videos, try and keep athletes who would normally be gearing up for Tokyo, or would, I guess, be wrapping up from Tokyo at this point, engaged, present, and keep them able to keep their Olympic dreams alive. So it's been a really interesting way to get kind of dip a toe into the creative industry, since I myself do not have a creative bone in my body, which is why I'm an attorney.
I find that hard to believe whenever anyone says that. Yeah. Let's see, Joanne.
Hi, my name is Joanne. Last name is Orts. I'm a CPA here in Seattle. I always say I don't have a creative bone in my body too, but then people always say everybody has some creativity. But I'm a CPA, right? I work with a lot of creative people in Seattle. I do accounting, taxes, and payroll for a few production companies, and I am on the board of Seattle Women in Film.
Thanks, Joanne. Amy, I am going to kick it off to you last and ask you to take us into the next phase of this agenda today. Talk about the survey.
Okay, great. I'm Amy Lillard. I do not have a creative bone in my body either. I always like to say I like to support creatives, but that is the work that I do. I am the Washington State Film Commissioner, and I run an organization called Washington Filmworks. And we more recently launched a partner organization called Whip Smart, which is a trade association to support creative workers and creative businesses. And very recently, we completed a social safety net survey, which I know sounds really exciting, right? There's nothing more exciting than a social safety net survey. That's why you're here tonight, I know. But we actually found out some really interesting information, and this is the first time we're talking about it publicly. So thanks to the City of Seattle for inviting us here to debut the data. But I thought it would be a really good place to start by talking about where the social safety net survey came from. So we at Washington Filmworks have been longtime partners with the Department of Commerce because we run an economic development agency for the state around film. And so when the pandemic started to hit, we went to the Department of Commerce and we asked them, we said, who is looking after the creative industries in the recovery legislation or in the recovery plan? And, you know, for those of you that don't know, big sectors of the economy has something called sector leads in the Department of Commerce who like connect with that industry to make sure that their interests are being discussed and taken care of. So, you know, sector leads would include maritime and aerospace and life sciences, right? So the creative industries does not currently have a sector lead. And so Whip Smart and Filmworks decided to jump in because it's so important that our interests are looked after by the state during the recovery. And we started to do a bunch of work. And so our work started really in earnest, I would say, in May, and bled, it's a terrible choice of words, but went into early June. And during that time, we had 27 focus groups around the state. They were both in communities across the state, so different geographic locations, as well as industry-specific roundtables as well. And what did we learn from those focus groups? Well, we learned certainly from the qualitative conversations that we were having that Washington State's social safety net was failing the creative industries without a doubt. So that could be anything from unemployment to food assistance to rental assistance, all kinds of social safety net provisions. And so while we knew that on a qualitative, you know, from a qualitative standpoint, we wanted to quantify it as well. So we wanted some data to back up what we knew to be true from our conversations. And so we're going to talk about some of that data tonight. And I'm going to start with things that are probably so obvious to this group and to this conversation and those people who are listening today. So some data, pre-COVID, 76% of the people who responded to the survey were employed in some capacity in the creative industries before COVID, right? So that's a nice, just 76%. As of July 1st, which was one of those dates that we put in the survey, 70% of respondents to the survey said their employment status had changed, right? So what does that mean? 46% reported that they had been laid off, furloughed, or became out of work. 24% said that they had a shift in the way that they defined themselves and they had become independent contractors, freelancers, or self-employed. So that's an interesting, you know, data point. We also heard quite a bit about unemployment insurance. You know, the first thing that we heard, was that it was the most accessed social safety net service for the creative industries. And B, it was the most helpful resource during this time of the pandemic. But we also heard that it was very difficult for creative workers to access unemployment. So we heard lots of different things, but some of them were around program design. So there were lots of conversations and data around the questions of creative workers being eligible. A lot of that comes from the way that we define ourselves as workers. A lot of data around how the system just doesn't fit the type of work that creative workers do. So going from job to job or gig to gig. And then interestingly, 49% said that they were delayed, rejected, or had repayment demands from unemployment. So in addition to program design, we heard quite a bit about program duration. 80% of the people who responded to the survey reported that they were concerned about the duration of unemployment benefits and that it wouldn't cover the need during the pandemic. There were lots and lots of colorful quotes that we gathered, but I really think that this one about unemployment, some of them I couldn't bring to the table tonight because there was a lot of inappropriate words.
Expletives.
Expletives, yes, thank you, Alex, for that word. But this quote, I think, actually sums up what we heard most about unemployment insurance. And it says, quote, the unemployment questions often make no sense to my situation. The questions often use terms which are not well defined or sound like they have a legal definition, but I couldn't figure out what it was. There's never a place to say, quote, my situation is special because of blank. You just get stuck in, quote, pending for a month and then see a rejection notice. The website is slow and half the time my clicks don't even register, so the page has to reload. I dread using the system at all. So we feel like that is a comprehensive overview of what we heard, and I'm sure the people who are listening in felt and have felt that. But while we could spend a lot of time talking about these kinds of data points and things that we know, I really want to focus on what we learned that was interesting, that I think will be interesting to this group, and then also what are we going to do about it, right? Because that's really what Whip Smart is about specifically. So there's a couple things I want to bring to the table. One is the data clearly show that there were one creative community. So creatives work in a diversity of disciplines. We knew that already, but now we have data to back it up. So we saw patterns in the data that we thought were interesting, and that you work in tangential creative industries or creative sectors. And so it's not like glass blowers are authors, but it's theater workers work in film and vice versa. Interestingly, there was a connection between musicians and graphic designers. And so again, we are all working in a diversity of creative sectors. And I think the work that we should do as industry and that we will work towards is how do we support creative connections between different disciplines as a pathway to find more work, right? If we make those pathways and those connections, more jobs and opportunities will come for creatives. So that was one thing that we thought was interesting. Another thing, which is a big conversation. I think we're going to dive into this later with the attorneys on the conversation. But film, theater, independent artists, writers, and performers are defined by the state of Washington as, quote, non-traditional workers, right? What does that mean to us? It means freelancers, gig workers, and self-employed. But the state calls us non-traditional workers. And there is a lot of you. Washington Filmworks and Whip Smart just finished the creative economy, something we are calling the Creative Economy Report for Washington State. And what we know from the data is that creatives make up 6.5% of Washington's workforce. And that's important because that's a lot of people. That is a critical mass that the state of Washington should and needs to pay attention to. But what's also interesting is that of that 6.5% of Washington workers, 65% of those workers are non-traditional or freelance gig workers or self-employed. So that's interesting, right? And especially as it relates to how we interface with the state. What's also interesting is that everyone has multiple identities. So in the survey was designed to allow for multiple definitions of how you as creative workers define yourself. What we found out was 63% of gig workers also identified as freelancers, right? The other thing that was interesting is that each creative sector, generally speaking, defines themselves differently. Film workers in the survey identified first as freelancers. Theater workers defined themselves first as creative gig workers. And finally, independent artists, writers, and performers first identified as practicing artists, and second as self-employed.
Interesting.
So yeah, super interesting, right? And the reason why this is important is because as we started talking to our partners at the state about this, what we learned is that every agency at the state defines each of these differently. Each agency seems to have a different definition of what is freelance, what is gig worker, what does self-employed mean. And so that by definition means, and by extension, so they all have different definitions, that means they interface and support creative workers or don't support creative workers all in different ways. So what is the work that we need to do as industry, right? So what can we do with this, what I think is super powerful information? First, we as industry need to define what we mean, right? We have to have consensus as industry about what these things mean. And second, we then need to interface with the state and start talking about, we're a big part of the workforce, so you need to pay attention to us and the work that we do. And secondarily, how do we make social safety net, as an example, available even though we're in this non-traditional workforce? So, you know, we've already begun this work. We have, after we did our work in May and June, started working with the Department of Commerce, who is doing a study for the legislature on, quote, non-traditional workers. And we made sure that the creative industries are included in that. And by included, we are one of 2 case studies, right? So, and that intention of that report, according to the Department of Commerce, is to lead to policy change. So that's one of the things we're doing now, but there's more work that needs to be done.
So you're saying that the Department of Commerce recognizes that policies need to change in order to support the way that people are doing creative work?
I think right now what they're trying to understand is what the landscape is, right? I think that the intention, and I can't speak for the researchers because they're doing the work, but I think they're trying to identify what being a non-traditional worker looks like. And I think that's the first step, right? I think that's the first step in the process because they have to understand what the landscape is like. And I think it will lead to, there appears to be in the legislature, and you're gonna hear about a bill tonight, that is intended to address this issue. But it's a web. It's a huge web that has multiple, like you pull on one string and like something else moves over here. So it's going to be a process, but you know, I think we as industry need to be part of the solution and instead of having the solution be given to us. And I think that's part of where we need to go. So, another thing I wanted to bring to the table that we learned during this process is something about our current environment. Right now, being employed, which means being on payroll, is the easiest way to access the social safety net. The work starts tonight in some ways because we're about to educate ourselves about what does that choice mean, right? I'm so glad that Joanne is here because we're going to talk about what that means from a definition standpoint. And then Joanne's able to talk. Joanne is our CPA who's here tonight, who works with lots of creatives. I think she's being a little modest. She's very well known for her work with the creative industry. And she can talk about what those choices mean to you from a financial standpoint, right? That's so important. So it's like, what is each of these things and what is the financial impact? So I want to get us started, of course, on the conversation, but I wanted to share with you in closing, one of the questions that we asked in the survey was, what matters most to you during these horrible, awful, no good, very bad times, right? Unemployment is the most helpful, right? That was for sure up there. But the second thing, which what I love, is that it was community building and solidarity within the industry. That was the second most important thing to us, right? So we all realize and recognize and know that there is a long road to recovery here. But as we move forward together and we come up with solutions, let's remember that it is community and solidarity in the industry and working together that's going to get us back to work most quickly. So with that, that's all I had to say.
Thank you so much, Amy. Any questions based on what y'all heard? Sounds like not only are the agencies speaking different languages, but creative workers are speaking differently about themselves. And so yeah, that solidarity piece is key. Singing from the same song sheet, as it were. No questions for Amy then? Oh, it looks like there was a question in the chat.
I might have a question. Well, I just, I do work in Southeast Seattle with the small business community. So doing advocacy, outreach, technical assistance, and actually working on putting a webinar together October 15th, the business of art. So as I am an artist, but I'm working with traditional, like the traditional definition of what is a small business. There's everything that's you're saying, Amy, today is just exactly how I want the conversation to be for this webinar that I'm working on. So but I haven't evolved my own. I'm not operating and involved in what the work that's happening. So I'm asking. I work with traditional funders who don't understand why they need to also include the opportunity to provide a grant to an artist or a small team, just a salon or a group of artists that are working together. And so it's the artist definition of how they're a small business too. That's a small business. And then it's also the funder and the foundation, so that having more of understanding how to include this in what their programs, their funding programs that they're developing.
You know what I love?
So I don't know that I have a question, but
no, and I love.
Sorry.
WhipSmart has been in development for a couple of years, and we wanted to make sure that little did we know we would really debut in the middle of a pandemic. But one of the things that drives us so much is this idea of raising the value of creativity, right? We talk about like the creative artistic side, but we also drive the economy. And that is part of the conversation that we need to really concentrate on so that funders get it in a more easy, like in an easy way, right? So that we can also talk about, like, when I heard that we're 6.5% of the Washington workforce, that's a big number, right? So that gives us something to work with. Policymakers or funders or, bankers can start to realize in meaningful ways. So we are actually going to, we're trying to go back to some kind of normal. WhipSmart over the next 6 to 9 months is going to concentrate on a financial literacy path, right? Where we're starting to help the industry either sustain itself during this crazy weird time and talk about raising that value proposition in meaningful ways. So I'm so glad you made that comment. And it makes me feel like, we've got something meaningful to give back to you guys. And so we're doing that, and you'll see it come out readily, actually. So thanks for that.
Awesome. Thanks, Amy. We got to move on with our agenda, but wondering if folks, what's the best way to get a report on this survey or anything related? Kind of what's the best way to stay in touch with you?
This is the first time we've talked about it publicly.
I just plugged your newsletter in the chat. So
okay, so there you go. So we do 2 newsletters, and we will obviously be releasing more information, not only from the social safety net survey, but from the creative economy survey, which was so enlightening. And I hope it empowers you as much as it helps us like feel great about what we do. But yeah, I think the best way to do that right now is to sign up for the newsletter, or if you have questions, info@washingtonfilmworks.org, I think is the best way. So.
All right. Thanks so much, Amy. Now is the time to turn it over to Jared and Ben to really get into the nitty-gritty of the differences between independent contractors and employees.
Okay, thanks, Alex. I think I'm going to kick us off, and Ben's going to jump in and take over for the second half of the presentation. Before I do a screen share here and show you our slides, I just wanted to let you know this topic can be a little dense. So we're gonna definitely leave time for questions at the end. If you track questions in the chat, Alex is going to try and keep track of them too. And if we don't do them in the moment, we'll try and circle back to them at the end.
Yes, and I also want to point out that Ben and Jared have graciously offered to provide this presentation afterwards. So you don't have to furiously take notes. You'll be able to refer to it. And I'll get a link out to you after the mixer.
Great, thank you. All right, well, hang on one sec. I'm going to do the share screen thing, and then we'll get going. All right, and okay, so you should all be seeing the slides now. Let me, great. So, our topic today is independent contractors versus employees.
A fight to the death.
Yeah. Before I even get started on the topic, though, I thought I should mention terminology first, because there's a lot of different ways that these kinds of workers are referred to. Independent contractor employee is the way especially lawyers will refer to it. Those are the legal terms to use for an employee. If you're talking about 1099s versus W-2s, you're talking about the same thing. If you're talking about a freelancer, you're talking about an independent contractor. So I'm sure there's differences. There may be differences in industry meaning, but with respect to the legal definition of what is and is not an employee or an independent contractor, those other terms have a similar meaning. So I'm going to really talk about independent contractor and employee. And so here's a quick agenda. What are we going to cover? We're going to cover the definitions. That's going to be kind of the bulk of what I'm going to talk to you about, to give you a sense from a legal perspective of where this line is drawn and how you draw it. We'll also, and as the second bullet point points out, this is not a precise analysis. In fact, this employs many hundreds of lawyers, thousands of lawyers across the country in order to help people manage the line. It's not an easy thing to do. So if you have felt or even feel confused about this issue when we're done, you are in good company, because it's not an easy thing to manage. And frankly, even with a law school education and experience, it can still be difficult. And then we'll talk a little bit about some practical issues, pros and cons, what are the risks, some about the creative industries, and in particular, Ben's going to talk about some emerging trends. Where does it look like this is going from a legislative perspective in the future? So first, the nitty gritty. I think somebody even put in a question before this started, can I just choose whether I'm an employee or independent contractor? Not in the way that question is raised. The answer is yes and no. There are legal definitions as to what is an independent contractor, and you can't just decide with the person who is contracting for your services which one you are. you certainly can decide and agree upon what kind of relationship you have. And it's the relationship that's going to define whether you're an employee or independent contractor. But simply putting down in writing that you're an independent contractor, if you're really not, isn't going to cut it. So you can choose the relationship, but you can't override some of these tests that we're going to talk about by just claiming to be something that you're not. And frankly, that's what has gotten many employers over the years in trouble, is trying to claim that people are independent contractors when they're not. There are, and you've already heard Amy talk about this, there are a multitude of tests. We're not going to go through each one line by line. I'm going to try and give you a broad sense of what's involved so that you can recognize it in the future. The key issues, as you'll see really soon, are control and economic realities, and I'll explain what those are. One last point before we dive into it is, it's important to understand that this bullet point, how are problems surfaced. These are issues that should come up in your discussions of when you are engaged to perform work, so that everybody has a clear understanding of this. In reality, these things come up more often through either complaints to some government agency who has responsibility, or basically after any harm or damage has been done or liability has been done. So this is the complaint, the enforcement of this by the government agencies is really a complaint-driven process. And I think the best example of this, probably in your industry that Amy came up with, is unemployment. When somebody stops working, they will claim unemployment. And if they have been treated as an independent contractor, that raises a big red flag and can lead to an audit of the employer. That's one. So but it's a good example how this comes up after the fact, when it's too late to really do anything about it in a proactive way. Okay, I guess this is the last qualification. We are entering the land of what lawyers would call factors and balancing. This decision is all based on a bunch of factors that need to be considered and balanced against each other. And if a court or an agency comes in and has decided to resolve a dispute, they're gonna have to weigh these factors and really come to an educated decision as to whether someone's an independent contractor or an employee. It's not a simple step-by-step checklist, as you will see now. So there's three main ways that people determine whether they're independent contractors. The first is, and these different tests are applied by different government agencies in different contexts. The first one, to start understanding what it means, are usually called control tests. These are most common at the federal level. They are in what we call the common law, non-statutory, basically the historic definition of what was an employee. So this is the test, for example, that the Internal Revenue Service will use to decide whether you have an employee for whom you need to pay payroll taxes. And as the name implies, the focus here is on control, namely the employer's right to control not the outcome of the work, but the means of how the work is done and the business of the worker. It doesn't necessarily matter whether the employer actually exercises that control. What matters most is that they have the right. And there's a couple of kinds of control at issue. The first one is behavior control. And you can see on these slides, the key thing is, does an employer have a right to direct and control how work is done? Not what work needs to be done, but how it's done. And some factors can include, do they give instructions? Do they provide the tools? Do they provide the equipment, the supplies? Do they provide training? All of these things, if there is such control, point in the direction of being an employee, not an independent contractor. Conversely, independent contractors are expected to bring their own expertise and entrepreneurial control over how they do work. A classic independent contractor is supposed to be told, here's what you need to do, go do it. And I don't care how you do it or when you do it, but it's got to get done in the way you've been asked to do it. And so anything that kind of takes away from that common understanding of an independent contractor pushes you in the direction of being an employee. There's also financial control factors. if you listed these out, there's like 22 factors the IRS considers. I'm consolidating them here in kind of bunches. It's the same bunches that the IRS would use. So financial control. Does the employer or the company have the right to control business elements of the job? And this mostly goes to the idea of, is an employee in business for themselves, or are they really just working for the employer? Are they offering services out on the open market to multiple employers, or are they just working for one? If you call yourself an independent contractor, but you're only doing it for one person and you do one company, you do it for a long time, that's a pretty significant factor indicating that maybe you're not an independent contractor. Does the worker have to pay for supplies? Do they incur the expenses? Do they have to invest in getting the job done, expecting to recoup that investment in the payments they receive from the company? If so, then you're a contractor. That's a more traditional contractor. But if your company is reimbursing you for all your expenses, then you're not. I think the key factor, the most important factor here is opportunity for profit or risk of loss. And that's a bit nebulous sometimes, but it basically means is, can you, through your own skill and ingenuity as a small business person, can you make more money if you work more efficiently, advertise well, or are you really just doing work for a paycheck? And then finally, this relationship factor, they will look at the intentions of the parties. Do you have a written contract? How long is this relationship? Does it have a defined end, like when the project is over, the relationship is over, or does it continue indefinitely? These are the other kind of factors. So this is probably the most friendly to being declared an independent contractor's test, but it does really focus on control. Now I'll pick up a little bit. Yeah, go ahead.
Bring up a question that came in when folks were registering. We got a number of questions, and one of them is, how do you see the concept of control changing between company and employee or independent contractor with work from home structures now accepted?
Well, I mean, I think most is probably, to the extent that work that was formerly done in an office is now being done at home in a more hands-off sort of way. It could possibly diminish the amount of control actually exercised. I think when deciding this question, especially if there was a history of work before the pandemic, I imagine they would look at how that work was done also, and not just look at the temporary removal. But it's more about what you're told to do than where you work. So if you still need to show up at a particular time of day and do work for a particular period of time, and you need to do it in a particular order or involving a particular manner of doing business, whether you do it at home or whether you do it in an office shouldn't matter to this test. I can definitely concede that it might get a little more murky if you're considering purely pandemic employment. I'm not going to go through every bullet point here because I know we have a short amount of time, but the economic reality test is kind of the middle ground. This is the most common kind of test that we see at our state level, but it's also the test that's used for, it's probably the most important one for your common concerns about, your non-tax concerns about independent contractors, because this is the one that is used to determine whether you're protected by federal and state wage and hour laws. And by that, I mean minimum wage, overtime, whether you get paid your paycheck on time, all that panoply of laws that protects employees to make sure that they are paid fairly and on time and that they're not cheated out of their pay. Those laws apply to employees and not independent contractors. And this is the test that will generally decide whether you're entitled to those protections or not. A lot of the some of the factors will sound familiar to you from what I just said. For example, the nature and degree of the company's control over the worker. And there certainly is overlap between these tests. The key thing I want to point out about the economic reality test, the real difference is the focus. So you have a lot of the same factors, but the focus isn't on control per se. The focus is on economic dependence. right? Is the employee dependent upon the employer, or does the employee have entrepreneurial control over their own work? So the ends to which you apply these factors are a little different in the economic reality test. And that, so you can see why it gets that name. So they will apply all these factors: control, permanency, investment, what kind of skill and expertise you bring. And that last factor, keep that one in mind, integration. That means, are you doing work that is typical for the company, or are you doing atypical work? You know, if you're a business, if you're a film production company who hires somebody to patch your roof, they're an independent contractor because you're not in the business of roof patching. But if you hire somebody to do a major component of film production, you're hiring somebody who's integrated into your business. They're doing the work that you do, and that's an indication that that person's is not in control of their own business, but really is dependent upon your business. So that's the focus there. And frankly, I find this one very difficult to apply sometimes. But I do think the key is to keep your focus on, am I dependent on the employer, or am I in business for myself? And I'm going to leave it at that. We can definitely answer questions. I wanted to get to, this is the third kind of test, and I'm kind of running up on my half of the time here. It's called the ABC test. I highlighted the A and the B and the C. This one is, this is the basis of this is the new test, newish test out of California. This is the one that new California laws have adopted. In our state, it applies to unemployment and workers' compensation. This is the most friendly to workers, in that it's most likely to find that somebody is an employee. And again, you'll see some overlap here, but at least in Washington, this one's really strict. It's not even though the factors have to be applied, you have to get all of them. It's not one or the other, or you don't balance them. You have to have A and B and C if you're going to be an independent contractor. And for workers' compensation, there's actually a slightly different, longer test. I think the one that makes this really difficult, if I were to direct your attention, again, control is still a factor here, but it's the middle one. It's the B and probably the C too, but the B is hard. This is the one I mentioned before. It's very hard under this test to hire somebody to do the kind of work that your company normally does as a non-employee. Not impossible, but difficult. It's also hard to satisfy this test, especially in Washington, if you don't have some of the formalities of being in business for yourself. You don't have to have your own LLC, but you do, if you're going to meet this test. It is very good if you kind of do have to sign up with the Department of Revenue to pay state taxes, and if not, you're going to be found to be not one. Of course, the consequence is going to fall on the employer in that instance. So I'm going to leave it at that and save questions on the detail for the question time. I just want a couple more things before I turn it over to Ben for his part. This is just some example, and Ben actually came up with this slide of the kind of language you would look at in a written agreement to sort of flag that sort of is indicative of a contractor versus an employee. So these are kind of your yellow flags for whether the employer is trying to get you to be one thing or the other. And they go to those factors. We can takeaways. This is my very quick version of trying to summarize for you these factors. Because you can't remember 55 factors from 8 different government agencies, what do you really want to keep in your mind when you're trying to assess what's the risk, or what kind of worker am I? Control, are you in business for yourself, or are you dependent on the business? Do you provide other employees supplies, skill? Is it structured like employment, or is it arm's length? And are you integrated into the business, or are you doing something unusual? That's where that's a starting point, I think. Finally, let's see. Okay, I'm not going over too much, a couple minutes. Finally, a little bit on the pros and cons. This one, there's this slide and the next slide. From a worker perspective, independence is obviously a big pro. They don't call it independent contractor for nothing. If it's a true independent contractor relationship, you have a lot of choice over who you do work for and when you do it and what you do. And that's really a big pro for a lot of people. So I don't want to undersell that. The next bullet point isn't really a pro. It's both a pro and a con. You don't have the money taken out of your paycheck immediately, but you are responsible for certain individual tax payments and self-employment tax or business tax. Intellectual property, generally speaking, employees, they work for hire rules apply automatically to employees unless there's an agreement otherwise. But it's the other way around for independent contractors. You're generally not considered work for hire unless you agree otherwise. So it gives you a little more opportunity. That can always be taken away in a written agreement, but you have a little more opportunity and leverage to control intellectual property, I think, under that status. The employee, the benefits are, I think, obvious. You just have a whole slew of employment protections that you don't have if you're an independent contractor. In a lot of industries, it is almost assumed that that's better than independent contractor. All the legislation is pointing in the direction of making it harder to be independent contractors because most people think it's better and more lucrative to be an employee. And they're not necessarily wrong, but in some industries those calculations might not be the same. Lastly, just so you can see it from the perspective of your the person hiring you, the benefits to employee is, to summarize all these things, it's cheaper. There's a lot of things an employer doesn't have to pay if you're an independent contractor. That's pretty obvious, but I think the thing to keep in mind too is, for an employer, you can be much more flexible. You can hire people as needed. It's easier to not have them around anymore if you do it correctly. But there's a ton of risk that employers sometimes do and sometimes don't recognize. This is a very volatile issue, very much subject to political change. What is right now may not be right in the future. And there's huge consequences to doing it wrong, from liability, individual liability, government audits, penalties to the government, tax penalties. And you just don't get some of the intangible benefits of an employee. You grow a relationship with them. You don't keep them around. You're at risk for being sued if they're injured, which is something that workers' compensation doesn't allow employees to do. Keep that in mind when you're dealing with this from an employer, and keep in mind too that those risks are often not well understood or well evaluated by especially less experienced or less savvy employers. So I had one more thing. I'm going to hang off on this one until there's time. If the inks, if we have time to get back to best practices, we can, or maybe Ben can talk about that too. But I'm going to turn it over now to Ben so he has time to talk to you about the remainder of these slides.
Good evening, everybody. First, thanks so much for having us. You're going to get a chance to hear from me about some of the emerging trends and case law, which I know is going to be just riveting. But first, Amy, it was great to have Amy because she built a big foundation for one of the things that I wanted to touch on, which is, why is this particularly important to the creative community? The basic stats are that many creatives are classified as independent contractors, may prefer to be independent contractors because of the way that the industry works. Basic stats from the NEA, 44% of creatives work part-time or part-year. They're 3 times as likely as your kind of average member of the workforce to be self-employed, whether that's as an LLC or as an individual. And they often have different start and stop times to work. All of these things, as you've already heard, can be pieces of tests as to whether or not you're an independent contractor. Now, one of the things that we think about when we look at both case law and legislation is not just the what, but also the why. What is happening? Why is it happening? What is the goal here? And one of the things that creatives are getting caught up in is the growth of the gig economy. And there's a really big expansion of independent contractors in the workforce as a whole. So that means 16% of workers in US businesses are independent contractors, which is a pretty significant increase from even 10 years ago. So even if creatives make up, in Washington State, 6.5% of the workforce, they're still very much in the minority of independent contractors. Where that becomes particularly important is two places. First of all, is that many of these independent contractors, whether creatives or otherwise, are older. And so when they're independent contractors, they're not getting many of the benefits that employees might get, which would include things like retirement accounts, protections for injuries, sick leave, other items. And that ends up costing the state a huge amount of money, both in terms of tax revenue and then also down the road in terms of supporting folks who don't otherwise have a safety net from private industry. And so when we look at both case law, because judges are, to a lesser extent, but still political animals and still subject to forces of the system, but also legislation, we tend to see the impacts of reality, right? And so the economic loss to the state and where these things, where the rubber hits the road, so to speak. In terms of when we're seeing these trends both in litigation and in legislation, when we're looking at litigation, what we're often looking at is broader pictures of independent contractors. So these are not cases that are specific to creatives, but they are elucidating rules that are then applied to all independent contractors, whether they are creatives or whether they're Uber drivers or DoorDash deliverers or truck drivers. So in 2016, Washington State Court decided that drivers who contracted with a company to perform courier services for third parties, so a whole different entity, were workers under the Industrial Insurance Act. And so you might say, so what? Who cares? And the reason that's important is because what we start to see is a broadening of the definition of employee, and that protections that are generally, or at least traditionally, were only extended to employees and not to independent contractors, are instead being extended to this broader base of people, which may include independent contractors. One of the things I wanted to touch on, many folks right now are facing job insecurity, maybe being asked to change their roles. If you are an employee, you may have been asked to cut back your hours. In some cases, you may have been asked to become an independent contractor. One of the things that really recently happened is that a court said that if you're an employee and you get offered a position as an independent contractor in lieu of your position as an employee, turning down that offer does not mitigate your damages. And so what that means is that the employer can't walk into court and say, I don't owe my employee money under the contract, even though I breached it, because I offered them a different job that would have paid them the same or a similar amount. And the court said, you can't do that because being an employee is a whole package of benefits that the employee bargained for and the employee wanted. And offering them a position as an independent contractor is not enough. It's not sufficient to say, well, they don't have any actual damages because they could have taken this other job that would have paid them the same or a similar amount. It's one of the things you really want to be thinking about if you're being asked to change from an employee status to independent contractor status, is what kind of claims can you bring and what are your rights down the road? Sort of the classic example of the misclassification of employees as independent contractors comes in the context of rideshare services, and in particular Uber. I think anyone who's been paying attention to this has seen a lot of these stories in the news, and a lot of it's coming out of California. And you'll see this too when we talk about the legislation, both because it's the largest population of not only creatives, but also independent contractors. And a lot of that's coming out of the tech sector. And the idea there, and again, this goes back to the different tests that Jared was talking about, but in the application of the test in that context, the court just determined that Uber drivers are presumptive employees because they provide a service to Uber. And so what that meant is that Uber has to come back and prove that they're not employees. So even though drivers were providing their own car, or in some cases deciding what hours they worked, when they worked, where they worked, the court held that it was obvious that drivers perform a service to Uber because Uber simply would not be a viable business without them. So again, it really goes to the core of what Uber's business is, and those drivers are an integral part of that business and therefore employees. And we see the same thing, and this is an earlier case from 10 years earlier in California State Court, and we see essentially the same ruling, that when it's the part of the business, when it's a core part of the business, you're an employee, you're not an independent contractor. In 2018, and again, you know, we're talking about California a lot because that's a real driver for legislation and litigation in Washington State. It's a driver for what we see in these emerging trends. And so in a case called Dynamex, the California court adopted the ABC test. And so Jared ran you through what that is, but what it is, it's the I guess in theory, most friendly test in terms of determining that somebody is an employee. So under the various tests, it's the most likely one to find somebody to find that somebody is an employee rather than an independent contractor. Now, Dynamex didn't stop there because the Ninth Circuit, which is the federal court for this part of the country, federal appellate court for this part of the country, took that decision and applied that retroactively. So it wasn't just employment contracts signed after Dynamex came out, but it was for all employment contracts leading up that get challenged at any time, or claims about independent contractor versus employee status. That decision has been withdrawn, but the California Supreme Court is deliberating it now. And so it becomes really important for past relationships where there may be a claim. And it also is the expansion of that ABC test. Similar, we've seen the same kind of more liberal approach from the Supreme Court. And there again, and this is similar to the Henry case, and the court applied a broader definition of employee and an expansion of who would fall under protections for employees. One of the things we are all kind of left wondering is what's going to happen when there's a new Supreme Court justice named to the Supreme Court. It is, from my point of view, fairly unfortunate. It's likely to be Judge Barrett. It's likely to make it a much more conservative court. And what that is going to traditionally mean is that we're going to see much more conservative decisions with regard to these types of issues. And so it'll be someone who is much more likely to read the text of a statute purely for the language of the statute and not look to the broader context. One of the interesting things about Judge Barrett is that we have very, 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 very little information about how she views employment matters. As an appellate judge, she only heard two real sort of employment type cases, and both of them were pretty run of the mill, and she didn't author either of the opinions. And in her academic writing, when she was a law professor at the University of Notre Dame, we didn't see any writings on employment issues. So we have a pretty limited idea of what she might be like, except to the extent that we can probably guess that she's going to be on the more conservative end of the court. All right, I'm through the really boring part, I promise. Now we're going to talk about legislation, which I think is probably a little bit more interesting for everybody. So in 2018, the Washington Senate passed Senate Bill 6032. And this actually was part of what Amy was talking about, is they funded a study about independent contractors in the state of Washington. The results of that study are available there. There's a link there. You can all see it. What I think was particularly interesting, and one of the things that I think tells you a lot about where they're headed is the study came out with 4 additional questions that they then want to research. And those questions are, to what extent do income and or education levels impact independent contractors' experiences related to financial hardship, access to benefits, and health insurance coverage? What occupations are most impacted in industries experiencing growth in independent contracting? What are worker demographics and household characteristics in occupations experiencing growth in independent contracting? And how do issues of financial hardship, access to benefits, and health insurance coverage for independent contractors compare to workers in traditional jobs? And I think that 4th one is really, really critical, because what it's going to drive is a lot of the ways that the state approaches future legislation. Because what we're seeing is a desire to expand and protect social safety nets. And so how do we make sure that people have access to healthcare, have access to retirement accounts, have access to benefits? And I think that the COVID-19 pandemic has really driven that even further home, is we really, really need to see ways that people can be protected, and whether they're independent contractors or employees, there's a need to make sure that people are able to put food on the table and keep a roof over their head. And so I'm really interested to see what we get from that, and where the results are. But it has not stopped there. So this year, the House introduced House Bill 1515, it's called the Employee Fair Classification Act. And again, Amy kind of beat me to this. One of the big issues we see is that different agencies across the state, different legislation, different statutes, all have different definitions and different tests for what an independent contractor is. And that creates this really kind of impossible and untenable situation. I thought one of the really good questions that got asked earlier in the chat was, what is a creative? What are the different ways that a person can be creative? Can you be a part-time creative? And that issues like this is where we really run into trouble, is if you're in 2 different industries, or you're defining yourself 2 different ways, you might find yourself under 2 completely different tests to determine whether you're an employee or an independent contractor. And that's really a pretty difficult and pretty untenable situation for everybody. It's hard for you, it's hard for an employer, it's hard for the state, it's inefficient, and it costs everyone money. And so the question is, how do you fix that? And this bill is one such proposal. Would make it a single definition across all those various different statutes. And it would create an enforcement mechanism where it makes it easier for somebody who's misclassified to challenge their classification. And then it does put the burden on the employer to show that you are in fact an independent contractor. Now, one of the interesting things here is that right now we're addressing an industry and a group of people who may have every desire to remain independent contractors. And that's one of the issues that we see, again, out of California, who passed California Assembly Bill 5. And what that did was it adopted the ABC test for everybody. This is what we're going to do. It had a very limited exception for bona fide business-to-business contracting relationships, where a contractor acting as a sole proprietor or a business entity formed as a partnership, limited liability company, limited liability partnership, or corporation contracts to provide services to another such business. And so what that really says is, unless it is truly a bona fide business, a separate business, contracting to provide a specific service, you're going to be an employee. They pretty quickly discovered that there's a lot of issues with kind of that blanket definition for a lot of the reasons that we've talked about, because it wraps up so many different people in so many different industries. And so they took a step back. And so just earlier this month, they enacted AB 2257, so Assembly Bill 2257, which expands many of the exceptions and creates a variety of different rollbacks of some of those protections. Again, because what the legislators realized is that this is not, independent contractors are not uniform. Your needs, your wants, the ways that you function within your industry are really diverse and need to be addressed on less of a blanket basis. Now, despite that discovery in California, Washington legislators have introduced what is essentially the same bill as AB 5, and it would adopt the same ABC test across all employment relationships. That hasn't gone anywhere yet. It's been introduced this session. I frankly have no idea whether it's going to go anywhere or not, but I'd encourage you all to keep an eye on it because it's something that is certainly going to have an impact on the way that you should think about designing contracts with customers going forward and your own employment status. On the national level, probably unsurprisingly, the federal government has gone the opposite direction. So earlier this month, the DOL rolled out a rule, Department of Labor rolled out a rule that clarifies what they say is that it clarifies the definition of an employee under the Fair Labor Standards Act as it relates to independent contractors. And it effectively moves in the other direction. It's a very employee-friendly rule. It keeps all these various factors that Jared was talking about in the test, all these different ways that people continue to take advantage of classification rules to keep people from receiving benefits as employees. And what it is intended to do is to act as a baseline. It doesn't overturn state rules. It will not overturn the amended AB 5, but it's provided as a baseline for states to build on. And so that's really kind of the other side of the coin. I think we've gone pretty long, and so I'm going to try and wrap up, but happy to take any questions. I see nothing was popping up in the chat, so obviously that was perfect, and there are no questions.
I might go ahead and unshare the screen here so we can see faces as questions come in, but we can go back if we need to.
Love it. Thank you both, Jared and Ben. If we were in person, there would be a raucous round of applause right now. What questions do y'all have?
I would love to ask a question if I can. For small film production or medium-sized film production, and I'm sure somewhere in there there's a scale where this starts to matter, it's hard enough to get any small production off the ground, and a lot of them are done with, who wants to volunteer some time for each other, and everybody helps out and does a weekend, helping everybody out. But certainly there are some roles that people like to pay a little bit of money for, and people would like to be able to throw $50 to $100 to their friend or whoever's helping out, doing whatever that day. And a lot of those are short-term, and they're done over the course of, at most a week. So they meet some of the factors. I'm curious what examples you might be able to give us of, okay, here's where it's like so integrated into a production that you're part of that business, and here's where courts have found like, no, that's cool, or some similar cases found like, yeah, that's fine, where it's like, yeah, throw your friend for $100, call a contractor and be done. Because the overhead of doing employment agreements for a small film would basically stop most small films from happening.
I want to also invite Joanne into this Q&A as she's got pretty close experience with these scenarios.
Thanks, Adam. It's a good question. I'll invite Joanne and Amy to contribute as well, because they have more experience directly with the film industry than I do, by which I mean a lot more. It's a good example of how these tests were not really designed to apply to this situation, because It certainly seems like if you're hiring somebody for a week or less to do a very small job, even though that small job is important to a film production, that you wouldn't need to hire them as an employee. And just as an aside, you don't have to have a written agreement to have an employee, but it does. You're right. It does put you on the hook for doing a lot of formalities. I think, without being able to tell you whether it is or isn't okay, I would say under some of the more important tests, even though that might fail the factor of, are they doing something that's really important to the general operation of the business, right there? But it could really be something where you would consider closely factors such as, is this a very temporary arrangement? is this person really bringing all of their own skill and expertise? Are they bringing their equipment with them? Is this somebody you know who has a camera and who's bringing it? So I think there's always wiggle room, and then there's always the factor of just whether you're on the radar or, whether you're on the radar for enforcement of these issues. My understanding, and here's where I'll stop talking, let Joanne and or Amy jump in. My understanding that is, as a general rule, as a general kind of industry understanding, is that in a film production, most of those production employees would generally be considered employees if you had a really strict application of these standards, and that it's the rare person who is a contractor. But with that, I'll let them talk a little bit about industry if they like.
I mean, that would be my take on it. Is it's typically, if you're on a film set, you're an employee because you're being told when to show up and how to do your job. But you're right. If it's a small budget production, you can't afford. You're not paying everybody. I will say though that it's my understanding that you can get L&I. You don't have to pay people as employees, but if you were concerned at all about it, you could get L&I coverage for people without paying them as employees.
That's correct.
So something to think about. But you're also shooting, it's a short production. Nobody's going to come after you.
But sooner or later,
Where you get in trouble is, and I think this is what Jared said initially, where everybody gets in trouble is somebody complains, right? Somebody goes to employment security and says, I should have been an employee. That's
right. If you have one unhappy person on a film set, which can happen, and you're trying to do things right in the first place, but it's, I'm trying to wrestle with that. Is L&I available through the state?
yes,
Or voluntarily? Okay.
yes. Different industry. So if anyone were to get injured on set, L&I would cover them.
So there's a couple things I want to bring to the table. It's my understanding, although it's lovely having lawyers on the call, that you may not volunteer for a for-profit entity, right? So volunteerism is reserved for a nonprofit 501c3 example, like as an example. So my understanding is that you cannot volunteer on a for-profit entity. So that's one thing to consider. The other thing that I'm going to drop in the chat here is very specific to the film industry. There we go. So we lean into our union partners quite a bit about industry standards. And so many, many years ago, this is dating back to August of 2013, the labor representatives and the labor leaders in Washington State consulted with their lawyers and wrote a letter about whether film is an independent contracting situation or not. And so I'm dropping that in there. And I'm also going to put Melissa Purcell, who's the business agent for IATSE 488, who knows more about the current labor, because this is from 2013, who could probably suggest, I'll put her email in the chat as well, but can also probably update folks about whether film specifically from their perspective is independent contractors or not. So those are the two resources that I would point you to generally in this moment, with the caveat that I think we all need to be aware that, again, there is this, if you're a for-profit entity, if you're trying to make a profit off of your film, then there's something that the state would look on in that environment if you have volunteers. So.
I'm going to ask, is there a distinction there between, is there a possibility of having if you're not a 501c3 as a nonprofit, but you're making a small film with no intention to actually monetize it? Is that still in the same area of not for profit, or?
I could make an editorial comment on making profit film, but I will not. I don't know the answer to that necessarily, so I apologize, but I don't know the answer to that right now, but I'm sure we can find out for you, Adam, if that's something. It's info@washingtonfilmworks.org for sure.
Yeah, I don't remember all the ins and outs of those rules off the top of my head, but Amy's generally right. It's very, very difficult to be a volunteer for a not for profit. Let's call it a not for profit rather than could say, and even then to be a proper volunteer there's yet another whole sort of factor test that is usually looked at for volunteerism, but the gist of it is it has to be basically for the benefit of the person volunteering, not for you. It has to be of some benefit to them, especially if you're a for-profit. You can't just say they're giving you services for free, call it volunteerism. They have to get something maybe of educational value or something out of it also. That's about as far as I can go off the top of my head, but I would not hang any hats on your ability to have a volunteer who's basically doing work for you from a strictly legal sense.
So I
Yeah.
just want to first comment that I look like I'm lit for a horror movie right now because I have no lights on. But I would love to ask Joanne, because you do what you do. We get this question a lot at Washington Filmworks, and I would just love to know from your perspective, like if you are a freelancer or an independent contractor, what are the financial impacts that you should be aware of, or how does that, like, what would be your advice to them in terms of not getting surprised by things? Like, I would love to get just like some tips from you since you're such a wealth of information.
Well, if you're an independent I always tell anyone who's being paid as an independent contractor versus an employee, and sometimes I have people who come to me and say, I have the option to get paid as either. Well, you should be charging a lot more as an independent contractor because you have to pay your own taxes. You're responsible for self-employment tax versus getting a paycheck and having that come out of your paycheck before that money goes in the bank. So you should be paid more as an independent contractor for that reason. But there's also advantages to being an independent contractor because you can write off your expenses. Where as an employee, you can't write off your cell phone, but as an independent contractor, you could deduct on your taxes your cell phone. So there's advantages to each, and I guess you need to be aware of that.
So can I ask a follow-up question to that?
Sure.
So another thing that we don't know how to answer is, and we get a lot from the community, is if you're an independent contractor and you still have to pay taxes, at what rate, how do you determine what rate you have to pay taxes, and how often do you have to pay taxes?
Well, as an independent contractor, you're going to pay self-employment tax, which is 15.3%. And then on top of that, you're going to pay federal income tax. But employees pay federal income tax, but as an independent contractor, that's not coming out of your paycheck, coming out of your check and being paid to Uncle Sam. So my rule of thumb for an independent contractor is 20 to 25%. Put that aside for taxes, because 15.3% of that's going to go to pay your self-employment tax, and the rest is for income tax. But you can take deductions against your gross independent contractor income. So my rule of thumb is 20 to 25%, and I find that that's a pretty good number. Now, how you pay those taxes as an independent contractor is you're required to make 4 quarterly estimated payments. Here's where it gets a little tricky, because you're required to pay in estimated taxes typically based on your prior year's tax. You can do that through withholding. You can do that through estimated tax payments. You can do it through a combination of both. So what I see with a lot of people is you work a lot of jobs as an employee and you work a lot of jobs as an independent contractor. So you've kind of got this mix of withholding, and then you make quarterly estimated payments. So you should be making quarterly estimated payments based on just your independent contractor income. And typically, what I would do is take 20 to 25% of that check that comes in the door and set it aside to make a quarterly estimated payment. And your estimated payments are due April 15th, June 15th, September 15th, and January 15th.
What happens if you don't?
Well, if you don't make those payments, so if you don't make any estimated payments and you get to April 15th and you owe money with your taxes, it's really just interest that you're going to pay. You're going to pay some interest. It's not really a penalty per se. It's interest from the day you should have paid that money in to when you actually pay it in. So you're really just paying a little bit of interest. I think it's right now it's about 2.5%. But that hit is always, you know, that for a lot of times come April, I mean, that can be a big number for people. I owe how much? It's, you know, it's much easier psychologically, I think, if you make those estimated tax payments, or at least put that money into a separate bank account. It's,
Okay, I know we don't have like but 1 minute left. Is there one source that we can go to, Joanne, to understand what is right, what you can write off in the creative industries and what you can't? I know that's not really fair to ask at this last moment, but I'm always curious.
what you can, I mean, you can write off anything job related, right? Anything that helps you do your job that's ordinary and necessary. That's the IRS definition. If it's ordinary and necessary to do your job. Where it gets a little tricky is when you work as an employee and you work as an independent contractor, you know, what expenses are really related to being an independent contractor and which ones are related to being an employee. You know, a lot of times I have to take all these expenses from people and kind of allocate. So also being aware that you can't just, if you're paid as an employee and as an independent contractor, you can't just deduct everything. You have to sort of allocate between the two types of work. But ordinary and necessary to do your job is.
Thank you.
Thanks so much. Yeah, we are at time, unfortunately. I do want to call some attention to this thing I'm putting in the chat. I just learned from Seattle Public Library that they are offering free legal consultations to anyone who wants to sign up. All you have to do is email l2b@spl.org and let them know that what you're interested in if you want to have a one-on-one consultation. I wish we had more time to get through some more questions, but this has been just so wonderful and such a rich information session. So thank you to our speakers, Jared, Ben, Joanne, Amy. You're all so appreciated. And I know Jared and Ben's information is on that, that PowerPoint that I'll be getting out to you all. You guys have the info@washingtonfilmworks.org email address as well. And of course, you can get a hold of me if you need to, and I'll put my email in the chat as well. Have a wonderful evening, everybody. Thank you so much for being here, and we'll see you at the next one, October 28th. Have a good night, everybody.